Good afternoon, everyone. This is going to be the Newcomers Guide to the Open Meetings Act, and we're going to get started in about 5 minutes. All right, good afternoon. My name is Brandon Lewis. I am an attorney advisor with the Office of Open Government. And this afternoon, we are going to discuss the Open Meetings Act. Just give me a second. I will share my screen. And if at any point during the presentation, if you have any questions, please feel free to drop them into the chat. And at any point, if you can't see this, the slides, also please just drop that into the chat and let me know. All right. As I said, my name is Brandon Lewis. I'm an attorney advisor with the Office of Open Government. The Office of Open Government, along with the Office of Government Ethics, are responsible for government transparency and ethics under the Board of Ethics and Government Accountability, which you know better as BEGA. OOG has been operating since April of 2013, and we are led by Director Nikel Allen, who you heard from this morning. The Office of Open Government interprets and monitors compliance with the Open Meetings Act, which requires that public bodies provide proper notice, access to, and detailed records of their meetings. We also provide training and guidance on the implementation of DC FOIA, as you heard earlier from my colleague, Anthony Skirbo. In general, the Office of Open Government advocates for government openness and transparency. And here's just a little blurb of information about FOIA, which if you did not get a chance to listen to Attorney Skirbo's presentation, that will be available later, as will this presentation, so you can avail yourself of that. Okay. The Office of Open Government provides guidance, including formal advisory opinions on compliance with the OMA. We also conduct trainings and outreach with regards to OMA. OOG can enforce the OMA on the basis of complaints from the public or based on our own investigations. And as a last resort, we have the power to sue public bodies in Superior Court for injunction, declaration, and/or civil fines. Here's the preamble to the Open Meetings Act, which states that the public policy of the district is that all persons are entitled to full and complete information regarding the affairs of government and the actions of those that represent them. The Open Meetings Act in general shall be construed broadly to maximize public access to meeting. Exceptions shall be construed narrowly and shall permit closure of meetings only as authorized by the Act. And so the first question when talking about the Open Meetings Act is who it applies to. It applies to public bodies. And so what is a public body? It is any government council, including the Council of the District of Columbia, any board or commission or similar entity, including an advisory body that takes official action by the vote of its members convened for such a purpose. There are also certain bodies that are excluded from the Open Meetings Act, such as the local courts and AMCs. Here's a list of, and the list is not exhaustive, but some examples of entities who must adhere to the Open Meetings Act. As we mentioned, boards and commissions are on here, government councils, including the Council of the District of Columbia, local school advisory teams, advisory boards, boards of directors, and public charter school boards of trustees. Who is not a public body? For the purposes of the OMA, district agencies, the mayor's cabinet, advisory neighborhood commissions, the District of Columbia courts, and the professional staff of public bodies when there's not a quorum of that public body present. All of these are exempt from the Open Meetings Act. Okay. A meeting is usually defined by its purpose, namely to perform public business, as well as by a quorum, the number of participants. All such meetings, unless specifically and legally exempted, are presumed to be open to the public, and the public must receive advance notice of the date, place, and a draft of the agenda of what is to be discussed at the meeting. What is a meeting as defined by the OMA? A meeting is a gathering of a quorum of a public body, whether formal or informal, regular, special, or emergency, at which the members consider, conduct, or advise on public business. This includes gathering information, taking testimony, discussing, deliberating, recommending, and you'll notice an asterisk there because we generally interpret this as and or voting, regardless of whether the meeting is held in person, by telephone, electronically, or by other means of communication. Okay, we get this question a lot. A meeting is not a chance or social gathering where no business is discussed. So for instance, if the members of a public body go and have lunch together and discuss no public business, that is not a meeting. A committee or subcommittee meeting of less than a quorum of the full body is also not a meeting. So for instance, if you have a board that is composed of 5 individuals and 2 of them are on a subcommittee for something, and they discuss something amongst each other, that is not considered a meeting because there is not a quorum of the body. However, if you had the same scenario where you have a board of 5 members and 3 of them constitute a subcommittee of some form, if those 3 members were to meet, they are also a quorum of the full body, and therefore the Open Meetings Act would apply. A meeting is also not a press conference or an email exchange. In general, quorum is a simple majority or more than half, unless it is otherwise established by the enabling legislation, mayor's order, or regulations. A note on electric meetings: a public body can meet via video conference, phone conference, or other electronic means if reasonable arrangements have been made to accommodate the public's right to attend the meeting. And all of the meeting or the applicable portions are recorded. All votes are taken by roll call, and all provisions of the OMA are adhered to. Okay. Next, we're going to discuss seeing in the chat that I think I may be frozen. So if you'll let me know when you can see me again.
Back on, Brandon.
Thank you. Okay, so as I was saying, with regards to notice of meetings, as much notice as possible should be provided, but notice must be given within 48 hours or 2 business days before each meeting, whichever is greater. Notice must be physically posted in the office or at a place that is readily available, or accessible to the public. And the notice must be posted along with the proposed agenda on the public body's website and or the district government's website, which is the central meeting calendar at open-dc.gov, which we host. In general, we advise that public bodies should post to both their website and to our website, just to facilitate the public's access to the meetings. However, either of those would fulfill the requirements of the OMA. Public bodies, however, must notice their meetings as timely as practicable in the DC Register. And the exception to this is meetings of boards of trustees for public charter schools. The notice must include the time, date, location, and or hyperlink if the meeting is going to be virtual, as well as the planned agenda. If there is going to be a closed portion of the meeting, the notice must also include the OMA citation with the reason for the justification for the closure of the meeting. Additionally, all draft and final agendas should contain this language at the bottom, which states, this meeting is governed by the Open Meetings Act. Please address any questions or complaints arising under this meeting to the Office of Open Government at open.govoffice@dc.gov. Then just a note on this, during the pandemic, there were exceptions that were made with regards to physical posting. However, effective August 3rd, 2023, all public bodies must resume physically posting public meeting notices, including date, time, location, or web link, and the planned agenda of each meeting in the office of the public body or at a location that is readily accessible to the public. And then as the same with notice on the internet, physical notices must be posted as early as possible, but not less than 48 hours or 2 business days, whichever is greater. Let's see. And then this is just reiterating what we just discussed with regards to posting, except that for emergency meetings, public bodies may either elect to use the usual internet posting method or post a physical paper notice in the office of the public body or location that is readily accessible to the public. Also, in that situation with an emergency meeting, you must also publish in the DC Register as timely as practicable, with the exception, once again, being for the boards of trustees of public charter schools. In the event of an emergency meeting, and this is the following procedure. When an emergency meeting is convened, the presiding officer shall open the meeting with a statement explaining the subject of the meeting, the nature of the emergency, and how the public notice was provided. With regards to emergency meetings, a public body may meet in case of an emergency, and the presiding officer must clearly state the nature of the emergency, open the meeting with a statement explaining the subject of the meeting, explain how public notice was provided, and notice must be given to the public at the same time that it is given to members. Okay. However, emergency meetings are not special meetings. A special meeting is a meeting that occurs outside of the public body's regular meeting schedule. The notice for a special meeting is the same as a regular meeting, as much notice as possible, but no later than 48 hours or 2 business days. Emergency meetings are reserved for true emergency situations or urgent matters where the meeting must occur and advance notice is not possible. And emergencies include instances that pose an immediate threat to health, safety, and welfare, or destruction of property. Okay, next, we're going to discuss closed meetings, which are also sometimes referred to as executive sessions. And these are governed by DC Official Code 2-575B. Okay, for a closed session, notice should include, if feasible, a statement of intent to close the meeting or any portion of the meeting, including citations to the reason for closure under Section 2-575B, and a description of the matters which will be discussed in the closed session. A closure in a meeting must include the OMA citation from DC Code 2-575B, the justification for the closure, and a description of the matters to be discussed. Okay, there's a full list of the reasons why a meeting may be closed that you can find here at the council's website, but some examples of justifications would be a court order or statute, contract negotiations, or trade secrets, attorney-client privilege. You should note, however, this is not merely the presence of an attorney at the meeting, but one in which the attorney would be advising the board in their capacity as an attorney. Public health and safety, where the disclosure would endanger members of the public, or to prevent premature disclosure of an award, or with certain administrative issues, exams, personnel decisions, or, for instance, something that would be discussing students' personal information. Okay. The protocol for entering into a closed or executive session. Sorry, I think we have a question. Does the reason need to be stated in the public notice filing? Yes. Ideally, like when you are composing your agenda, and if you know that there will be a closed session, you should include that there will be a closed session on your agenda and state the reason as set forth, as we previously discussed in the DC Code. Okay, so the protocol for entering into a closed or executive session, you would start the meeting as you would normally, establish a quorum, and open the meeting for to the public. If the meeting was a hybrid of an open and closed meeting, you would discuss any business that is in the open portion for the public, and then a member of the board would move to enter into executive session. And when they do so, they must include reference to the OMA citation which is justifying closure. For instance, if you are closing the meeting to consult with the board's attorney, for instance, you would cite that reason and cite to the DC code. Then at that point, you would take a roll call vote. And if the motion passes, you would enter into a closed or executive session at that point. Okay, and the protocol for a closed session. During the closed session, only the matters that have been referenced on the agenda can be discussed. So you can't go into closed session and discuss some entirely new issue that has not already been indicated on the agenda. Also, closed session must be recorded just the same as the open session, and that recording must be preserved. At the conclusion of the closed session, you would reopen the public session and, where appropriate, report publicly any official action that was taken by the body in closure, and then at that point, adjourn the meeting. Next, we're going to discuss recordings. All right. Under DC Official Code 2-578, all meetings shall be recorded. As I was just mentioning, this includes open and closed sessions. Only where a recording is not feasible, detailed meeting minutes shall be taken. That language is a little bit misleading because you should be taking detailed minute meetings regardless, particularly in the instance that recording measures fail, and we will discuss what qualifies as detailed meeting minutes in just a moment. Copies of records shall be made available for public inspection. The minutes as soon as practicable, but no later than 3 business days after the meeting. And for public charter schools, it's no later than 30 business days. The full record must be made available as soon as practicable, but no later than 7 business days after the meeting. Draft detailed meeting minutes must be publicly available no later than 3 business days after the meeting. A notation must be included at the top of the document that detailed meeting minutes will be posted to the website on the next meeting date. Audio recordings. Question for closed sessions, would that be a separate recording from that of the open portions of the meeting? Now, this may be something that you would have to discuss with your IT if there was a way to keep them on one, but we generally advise, if you're able to do them separate, that may make it easier for you, but both portions of the meeting must be recorded. Okay. Audio recordings, video recordings, and transcripts. A copy of the full record must be available, as stated before, no later than 7 business days after the meeting. Okay. And detailed meeting minutes shall contain the date, time, and place of the meeting or session, the names of members of the public body recorded as either present or absent, and any motions and amendments thereto, a record of all votes taken, and general description of all matters considered. And this is important because sometimes people think that detailed meeting minutes mean that you have to transcribe or write down everything that everyone said, everything that took place. However, as you can see here, a lot of this information will already be on the agenda for your meeting, such as the date, time, and place. So to have detailed meeting minutes that satisfy the requirements of the statute, you just need the additional things here, the names of the members recorded as either present or absent, and then the actions taken during the meeting as listed in C. Okay, record maintenance, 3 DCMR, section 10409.8 requires compliance with district record preservation law and the District of Columbia General Record schedules concerning the disposition of its electronic meeting recordings and written meeting minutes. DC Official Code Section 2-578A requires the preservation of all meeting recordings for a minimum of 5 years. And then this is just a summary of what has already been mentioned with regards to the requirements for the full record. Next, we're going to discuss public comment. This comes up a lot. So it bears saying at the beginning that no public comment period is required by the OMA or its regulations. Now, a public body may allow public comment subject to internal parliamentary law, or they may have a standing order permitting public comment and regulating its timing, germaneness, advanced sign-up, etc. But these factors are beyond the scope of the OMA and OOG. So sometimes we receive complaints from the public that they attended the meeting of a public body and they weren't allowed to speak. Under the OMA, that is actually acceptable unless that particular body has their own rules or bylaws that permit or require public comment. So a public body may have enabling legislation or bylaws that mandate a period for public comment. Public body may allow public comment absent a statutory requirement to do so, simply because they have decided to allow public comment. And a public body has the right to regulate the time allotted and duration of public comments if they choose to allow them, unless the requirement is already spelled out in enabling legislation or bylaws. Next up, cancellations. Obviously, things happen. Sometimes meetings are canceled. So a meeting cancellation is a change in schedule. In most instances, cancellation requires as much notice to the public as possible, but not less than 48 hours or 2 business days, whichever is greater before the meeting occurs. To establish a record, the meeting notice to the public must state canceled. Director of Open Government can provide advice and training on parliamentary procedure upon request. And if you stay with us this afternoon, the presentation immediately following this will discuss parliamentary procedure. It's being presented by one of our former colleagues, Nick Weil, who has graciously agreed to join us and discuss this further. However, should you need any help with parliamentary procedure, we are available to help you with that. The office also has a parliamentary procedure portal that we can direct you to, which can help you learn how to conduct a meeting. Also, parliamentary procedure scripts for common tasks is good practice for the administrative point of contact, which we'll also discuss in a moment, to write a script for the presiding officer of the public body to use to move smoothly through the meeting and to ensure compliance with the OMA and with the body's internal practices. All right. So speaking of administrative points of contact, similar to FOIA officers, APCs act as the legally responsive personnel to whom we address OMA violations or other concerns. So for instance, if we are monitoring a meeting and we notice perhaps that someone didn't enter into closed session correctly, we would then reach out to the administrative point of contact at that board or commission and let them know what happened and see how we could help them to comply with the OMA. Okay. Whenever an administrative point of contact changes hands, someone has moved to a new position and someone else is taking over, we just ask that you all provide the new point of contact's name and contact information to us here at OOG. Additionally, for access to our central meeting calendar to post notices and minutes or transcripts, the point of contact must contact us to obtain login credentials to access the user side of open-dc.gov. And the OMA also permits the use of a public body's own site for posting these records. OOG offers the central meeting calendar as an alternative and a supplement, and for district-wide convenience and uniformity. And so, as I mentioned before, we recommend that wherever possible, you post to both your own website as well as ours, as it just provides more information and ways for the public to access meetings. Now we're going to discuss complaints. So an aggrieved party, including anonymous parties, can complain to OOG for relief. This may be prospective, or it may refer to meetings that have already taken place. So except with allegations of imminent prospective violations, a public body has up to 30 days to respond, with a possible extension of up to 5 business days. And the Director of Open Government may seek to resolve the dispute through conciliation, dismiss the complaint, release an advisory opinion, or take any other step that is permitted by the OMA and its regulations. With regards to enforcement, OOG may bring a lawsuit in the Superior Court of the District of Columbia for injunctive and/or declaratory relief for any violations of the OMA before or after the meeting takes place. That's DC Official Code Section 2-579. Okay. And the court may render an appropriate remedy, such as requiring additional forms of notice, postponing a meeting, or levying a fine of up to $500 per violation. These are just some additional sources, information. This is our website, open-dc.gov. And also at open-dc.gov, you can find an OMA compliance checklist that will help you comply with the requirements of the OMA, and then, of course, the DC Official Code and DCMR. This is our contact information. We can be reached at open.govoffice@dc.gov, as well as the number here. And then here are our individual email addresses as well. I'm going to stop sharing my screen because I was trying to get to the questions as they came in, but I think I may have missed some. So I'm going to come back around, make sure. Let's see. And I see also one of my colleagues has also provided the link to the parliamentary procedure portal in the chat, if that is something that you're interested in.
I believe you're caught up on questions from the chat.
Okay, great. Thank you. Okay. So if there are no further questions, thank you very much for joining me for the Newcomers Guide to the Open Meetings Act. As I mentioned before, coming up at 2:45, we have a presentation on parliamentary procedures. So if you're able to, we hope that you will join us back for that. Thank you.